Welcome to Canada's most irreverent talk show. This is the Andrew Lawton Show, brought to you by True North.
Hello and welcome to you all. This is Canada's most irreverent talk show, the Andrew Lawton Show on True North, live on this Tuesday, January 23rd, 2024, just after 1 o'clock Eastern Time. That makes it just after noon Central. If you are in beautiful Alberta, it is nice mid-morning 11 a.m. for you on the West Coast, slightly earlier mid-morning 10 a.m. If you're in Atlantic Canada, I always get confused with the half-hour time zone, but some very, very good news for you all if you are supporters of freedom, as I suspect many of you, I certainly hope many of you are after several years of doing this show. Just in hot off the presses from the Federal Court of Canada, the Emergencies Act regulations invoked by the federal government just 2 years less a month ago were outside the parameters of the Emergencies Act, and more crucially, were unconstitutional. This is a lengthy decision that just came out within the last hour, 190 pages from the federal court. I'll get down to brass tacks here. It is declared that the decision to issue the proclamation and the associated regulations and order was unreasonable and ultra vires the Emergencies Act. That means outside the legal bounds of it. It is declared that the regulations infringed Section 2B of the Charter and declared that the order infringed Section 8 of the Charter and that neither infringement was justified under Section 1. 2B is freedom of expression, part of the Charter, sacrosanct human right in this country. And Section 8 is a more interesting one. Section 8 refers, well, it's legal rights, but we'll get to that when we talk to Christine Van Gyn, who is the litigation director with the Canadian Constitution Foundation, and joins us now. Christine, I know you've not had, lawyers are very speedy readers, but I know you haven't had time to fully digest 190 pages just yet, but what's your early reaction on this case here, and what was your role in it?
So our role, we were one of the parties that brought this. This was brought by the Canadian Constitution Foundation, which is a national legal charity that fights for fundamental freedoms in Canada, as well as by the Canadian Civil Liberties Association, as well as by another organization called Frontline Nurses, and by some individuals who had been affected by the emergency measures. For example, individuals who were arrested for breaching, or I guess they actually weren't charged under the emergency measures, but they did have their bank accounts frozen. So the reaction is I'm absolutely thrilled. I didn't know what I was expecting. You know, you kind of try to brace yourself when you are dealing with this complex litigation that goes on for extended periods of time. I mean, I didn't know what to expect. My best hope, I think, was surpassed with this, because we really won on everything. The crux of this case is that the invocation of the Emergencies Act in response to the 2022 Freedom Convoy was unreasonable and ultra vires, which means outside the scope of the authority of the government. And then the other major issue was whether or not the actual regulations that were created under the Emergencies Act, which is prohibitions on gatherings that prohibited people from protesting, and or going to a prohibited protest, and then the economic measures, which ended up freezing people's bank accounts. And the court found that those measures were unconstitutional. They violated the Canadian Charter of Rights and Freedoms. And there's also some discussion in the case about the Bill of Rights. I mean, I'm 90 pages into the decision, which I got less than an hour ago. I'm trying to get through it as quickly as I can for initial reaction, just to see what the big issues are. And then I'm going to obviously do an even deeper dive after this. But my initial reaction is this surpassed my expectations. This is a wonderful day for fundamental freedoms in Canada, for the right to protest, and a wonderful day on, I mean, I think a lot of Canadians throughout the pandemic had their faith in our justice system really challenged because there were a lot of decisions that didn't come down the way we had hoped. This is a huge exception. And I think that in the context of the pandemic, the invocation of the Emergencies Act was the most extreme piece of government overreach. And here we have a court slapping down the Trudeau government for having done that.
And just to put a finer point on this, and please, if I've misrepresented this, correct me, but as I understand it from what you said and what I've read so far, the court has found that there was no emergency, basically, in keeping with what the Emergencies Act has said. And even if there were, the measures employed were not constitutional. Am I understanding that correctly?
So I haven't got to the second part of your question yet, but I'll read directly from paragraph 255 for you. For these reasons, I conclude that there was no national emergency justifying the invocation of the Emergencies Act, and the decision to do so was therefore unreasonable and ultra vires. Should I be found to have erred, he then goes on to discuss some of the different threshold requirements, because the invocation of the Emergencies Act, that piece of extraordinary legislation, actually has a number of internal thresholds, like threat to the security of Canada and a requirement that the law be a law of last resort. Now, 90 pages in, I'm not at those parts yet, and I haven't got to the charter arguments on the actual regulation, so I can't comment on that yet. But I know the result, which is that they were found to have been a charter breach.
And not saved by Section 1 of the Charter. Let me just pull ourselves out of this decision for a moment here. And I just want to, maybe this is a bit of a civics lesson for people, but we went through this massive public order emergency commission last year. And at the end of that, Justice Rouleau, or Commissioner Rouleau, had concluded that the Emergencies Act was satisfied. That threshold was satisfied. So which is more important, really? And how do we rationalize and sort of reconcile these two these two inherently contradictory findings?
This is a really important question. This case is no question more important. The actual decision from a court has much more weight. The Rouleau decision has no precedential value. It would be of political consequence, but I don't want to invalidate that as an exercise, because one of the really important things that helped us to actually achieve this result in the court case was because the Rouleau Commission had this extreme level of transparency, and we were able to access all kinds of cabinet documents that we otherwise would not be able to access. Mm-hmm. Which actually we had, in this case, the government had been fighting us over the disclosure of these documents that we wanted, and we were able to access them because they ended up becoming public through the Rouleau inquiry. So that, even though I totally disagree with the result in that inquiry, it still was a really important part of the process that led us to this result, which has a huge bearing and weight on how this emergency legislation can be used in the future. I think the long-term impact of this decision is that this will rein in some of the concerns that we had over the government now having, unleashed the Kraken, and they've now used this piece of extraordinary legislation. I think there's going to be a lot more restraint now, because they've really been slapped down for this. This is an absolute loss for the Trudeau government. They couldn't have lost worse. Like, this was
that's
the
fair.
worst
And I know
scenario.
This is not a COVID case. I think a lot of times it gets lumped into the landscape of COVID because that was the environment that birthed the Freedom Convoy, which to the government birthed the Emergencies Act. So this isn't a COVID case, but I do think if we look at all of the pandemic challenges that have been there in the last couple of years, one thing you and I have talked about, I'll say lamented on stage and on this show, has been how deferential courts have been to the state over this period, including on freedom of expression issues. So it is really a divergence from what a lot of the jurisprudence has been on some of these cases of this era over the last few years, is it not?
It is, yes. I think that this was a case, though, where I think one of the issues with the COVID era cases was evidence, and that it was difficult to litigate with the scientific evidence as the basis about, how dangerous is the virus. And there was a lot of deference given to the government about that. And there was a kind of a lack of scientific evidence that was in the court cases themselves. Now, some of the cases, there were some in Manitoba that had some discussion of the evidence, but for the most part, it was not litigated on the science. So it was, in the end, the courts ended up having deference to the government. In this case, this is a more straight principles of law, and there actually, in this case, was a huge amount of evidence because of the Rouleau inquiry. We had all of these affidavits. We had all this evidence from testimony, from policing experts, from cabinet ministers. So there was a lot here to help the justice reach this conclusion.
And you also had the government attempting to have this dismissed on mootness grounds, which the judge clearly did not do. And I think we can be very grateful for that fact. But that was one that I found quite notable, that we have such a massive, unprecedented legislation, incredibly controversial usage of it, and the government didn't even want there to be a judicial review on it.
Yeah, I think that that's such an offensive notion, that this piece of extraordinary legislation, that by its very nature is temporary. Anytime you invoke emergencies, are just temporary by nature. That's what makes it an emergency. And the idea that you could never scrutinize the use of this legislation, because by the time you get to court, the emergency is over. This is like a preposterous type of suggestion by the government. And now the judge, Justice Mosley, did find that the case was moot. I mean, the facts on the ground were done, but of course, courts have the inherent discretion to hear a case in spite of its mootness. So he did proceed to hear the case, even though, the protests obviously had resolved and the emergency declaration had been revoked. It was only in place for a very short period of time. And this was a huge issue in the hearing, where Justice Mosley just did not seem to be buying it at the hearing. He said, in what context would a court ever hear a challenge? Because it's always going to be over. The emergency is always going to be over by the time it gets to court. And the Attorney General really tried to wiggle out of that one. But I mean, it is what it is. And the judge is right in this case. It's always going to be over by the time you get to court. And we're happy that this absurd mootness argument was rejected.
We are going to have you back tomorrow for a deeper dive into this once you've had a chance to pore over it here. And I know there are going to be a few things that you'll be looking out for specifically, but I just wanted to ask you, is this effectively a guarantee that the government is going to appeal this to the Federal Court of Appeal?
If I were a betting woman, I would bet they're going to seek leave to appeal. They haven't said so yet, but I would be absolutely shocked if they don't appeal. I mean, I'm interested to see what the government's statement on this is, because I mean, it's a brutal loss for the Trudeau government today.
Well, and you may not have seen this. They had a bunch of media appearances planned from ministers who have all now gone into hiding in Montreal. Like Bill Blair was about to speak, and now they've shoved him out the back door and canceled this. So
one thing I would say, though, Andrew, is that I mean, I'm certain that the government is going to try to appeal this, or they're going to seek leave to appeal. They haven't said it, but I would bet that they are. And this is a case that is tremendously expensive. So if your supporters care about this issue and they want to see us successfully fight an inevitable appeal, they can make a donation to our legal fees at the ccf.ca/donate.
Yeah, there was no, I noted in the decision, there was no cost award here. So it's not even like the government is, forced to give you a token for, having bought this.
We actually typically don't ask for costs.
Okay.
There's maybe a few exceptions, but I mean, that's taking your and my money, Andrew, because we're always suing the government.
You're taking the libertarian approach. Let those who support this fight support you. Well, that website is theccf.ca. Again, Christine, congratulations. We will talk to you on the show tomorrow in a bit more depth on this, but well done.
Wonderful. Thanks, Andrew.
Thank you. Thank you so much. That was Christine Van Geyn, litigation director for the Canadian Constitution Foundation. Incredibly important decision. Now, I've been working my way through it. Like I said, I can read quickly. The judge has written it in a very fairly clear way, but you're still reading in some ways legalese, and you're still reading 190 pages of it. So this is going to take a little bit of time for me. So I'm learning some things as we go here. Just a couple of points that I want to stress. If you're just tuning into this show, the federal court has found the Emergencies Act was unjustified. The measures invoked with the Emergencies Act were unconstitutional. So this is crucial because the judge could have found one or the other. He could have said, yes, there was an emergency, but no, the measures weren't valid, or no, there wasn't an emergency, but these measures were keeping with the Constitution. The judge has said both were wrong. So the federal government found an emergency that in the law did not exist, and more importantly, used that emergency to do things that were utterly unconstitutional. What things, you may ask? Well, freezing people's bank accounts, warrantless seizure of finances, arresting people for participating in whatever the government deemed was an illegal assembly. This is massive. And as Christine Van Geyn just said, this is more important than the Public Order Emergency Commission, because in this case, we have a decision that is binding. We have a decision that has precedential value. We have a decision that is telling the government, you broke the law. Justin Trudeau broke the law. So no wonder the Liberal government and its ministers right now have gone into hiding, because how are they going to answer this utter slapdown? And look, I've had a fair number of things to say about courts in Canada that have been critical, because I found courts have been overly deferential to the government, especially on matters of civil liberties. But this is a case of a judge, and by extension, the court. The judge represents the court in this decision, doing something that is actually, it looks like, very well rooted in what the law is supposed to be. Just a few other reactions I'll point out here. Andrew Scheer, who is the former leader of the Conservatives, and now he is a lieutenant, a House leader for Pierre Poilievre, has said that Justin Trudeau froze bank accounts and had protesters trampled. Never again let Trudeau give a lecture about charter rights. We have a post here on X, formerly Twitter, my colleague Cosmin Georgia pulled out here. It is a scathing indictment of the government and its use of the Emergencies Act here. The highlighted bit says as follows: the Emergencies Act is a tool of last resort. The government, that's what GIC is, cannot invoke the Emergencies Act because it is convenient or because it may work better than other tools at their disposal or available to the provinces. The evidence is clear that the majority of the provinces were able to deal with the situation using other federal law, such as the Criminal Code and their own legislation. So this is a court finding what every police agency and every provincial government except Ontario said, which is that we could have dealt with this on our own. The federal government put the Emergencies Act in place when it was not needed and was not requested. And you may say, well, hang on, it worked. They put it in, and then a few days later, the convoy was gone. Yeah, but that was because police decisions were not moving towards what the outcome was. They had a plan in place. They weren't actioning that plan. But the judge there really honed in on that and said, this does not mean that because it would be convenient, it is justified or legal. So what we saw here is that the government the government gave police marching orders. The government found justification where none existed and used it to trample on your freedoms. We see reactions coming from a number of Conservative members of Parliament here. Blaine Calkins, who is a Conservative MP, says Trudeau has no business continuing as the Prime Minister of Canada. Wedge, stigmatize, and divide the Trudeau way. What restitution is owed to those harmed by this abuse of power? Apologies, Trudeau. Millions of Canadians are waiting. That's a reaction from Blaine Calkins. Michelle Rempel-Garner, Conservative MP from Calgary, says this is a huge decision. I have reached out to Conservative leader Pierre Poilievre's office, and they've told me that a statement is coming, although we haven't had it yet. I'm assuming they're whipping that up post haste, and we'll get to it now. Everyone's like texting me. So this is breaking news here. I hope it's accurate. It's coming from one colleague. I'm just going to read it because you're telling me this. It better be true. Chrystia Freeland has said, and maybe I won't say it. We're being asked about a source now. Okay. Okay, according to CPAC, thank you, Artem. Chrystia Freeland has said they are appealing the decision. So I don't even know if they've read the decision yet, but the federal government has already determined it is going to be appealing this decision. So the federal government, despite this strong rebuke and condemnation, the federal government is holding firm on this and saying we did everything right. So this is quite massive. We're going to continue to discuss this as the show progresses here. But just to recap, the Emergencies Act, unconstitutional. The measures brought into place under the Emergencies Act, unconstitutional. The federal government, unrepentant. So a little bit of wordplay for you here on this Tuesday afternoon. This is so big, and let me just point out here the obvious. Well, it may not be obvious to a lot of you. Today is January 23rd. It was 2 years ago, exactly 2 years ago to this day, that the first convoy of trucks left from Delta, British Columbia, on their way to Ottawa for what became known as the Freedom Convoy. This is the protest that picked up steam in Alberta, was later joined by groups in Saskatchewan, Manitoba, groups from Ontario, Quebec, and Atlantic Canada came. They all converged in, basically January 28th, 29th. We'll do a little anniversary for that as well. They converged on Ottawa. And they did this because of a message for freedom. Now, you can say that you don't like the tactics, you don't like some of the people involved, but this protest about COVID restrictions and vaccine mandates became about something so much more when the government showed the lengths it was prepared to employ the Emergencies Act to rein in and clamp down on peaceful protesters. That's exactly what happened. And that was why even people who did not support the protest and did not support the convoy were condemning the Emergencies Act. Even Paul Champ. Now, Paul Champ is a lawyer who's representing the people in Ottawa in this like absurd multi-gazillion dollar class action against the convoy. Even he said he opposed the Emergencies Act. So you didn't have to like the convoy to realize that the government had overreached here. Want to bring into the discussion Keith Wilson, who is, literally was the most visible and prominent lawyer representing the convoy organizers during the Freedom Convoy. He was stationed in Ottawa and thankfully got out without his bank accounts being frozen. Keith Wilson joins us now. Keith, it's good to talk to you again. Thanks for coming on today.
Thank you.
So again, I know this is something that will take some time to fully digest here, but what's your early reaction to this decision? And let me just say, given how pessimistic a lot of people who advocate for constitutional freedoms have been about courts, are you surprised by the decision?
I'd say I'm relieved. I was getting, as you know, Andrew, very, very concerned about the institution of our courts and whether Lady Justice blindfold had been pulled down, because it certainly seemed like it had with a number of the decisions, including my case involving former Premier Peckford on behalf of 6 million Canadians, unvaccinated Canadians who lost their mobility rights. But this is a great day for Canada. It was clear to anybody who was on the ground in Ottawa, as I testified before the public inquiry in the fall of 2022, the Rouleau Commission, that none of the requirements for the Emergencies Act to be invoked were present on Monday, February 14th, Valentine's Day in 2022. The borders had all reopened, Windsor, Coutts. There was no protest there. The only protest left in Canada was the significant protest in downtown Ottawa, which was causing tremendous embarrassment, quite rightly, to the Trudeau government. And they invoked it to clear out that protest, tragically, with brutal, tyrannical force against lawful protesting Canadians. And it was clear to us that the legal test for the invocation wasn't met. We made public statements live at the time that the legal test, there had to be threats of serious violence to overthrow the government. That wasn't the case at all. So I was disappointed in the whole Rouleau process. It turned out to be political theater, obviously. I was holding out hope that our federal court would apply the law to the evidence and conclude the obvious, that the legal test for invocation of the Emergencies Act was not met. The actions of the Trudeau Liberals in stripping Canadians of their most basic rights and using violence against them was illegal. And that's what the court has ruled today.
I know it's difficult to concoct an argument on behalf of the government, which I think has probably shown itself to not be particularly interested in freedom. But we had the breaking news a few moments ago. Chrystia Freeland says the government will appeal this decision. Do you know? I mean, maybe it's premature, but do you suspect what grounds they may use to do that?
They'll be weak. That's a sign of desperation. The decision's 120 pages long. I haven't had a chance to read it fully, but I understand the area of law well. I understand the legal arguments well. I need to congratulate, you'll remember Brendan Miller from the Public Inquiry. Just so you know, this is his brilliant legal work in action. It was Brendan Miller who led the charge with some other lawyers on drafting and crafting this legal argument and preparing the factums. So another tip of the hat to freedom fighter Brendan Miller.
So, as we talk about the state of the Constitution here, I mean, the Emergencies Act itself is relatively untested as a law. So, this has precedential value for that. Do you think it advances freedom of expression more broadly, or does it really just pull from what had already been or was supposed to be the established approach to freedom of expression in Canadian law?
I don't know yet, Andrew, because as you can appreciate, this has happened so quickly, and I was in a meeting when it occurred, and I had to rush back to my office to prepare for
I know
this.
I already had a show planned on something else, so I understand. I'm sympathetic to that.
Yeah, I made some commitments to someone to have some deliverables of today. I said, unless something big happens, and little did I know. I don't know yet, and I will be happy to analyze that. But what I can say with certainty is that, when the government is going to take these extraordinary steps of arbitrarily freezing hundreds of Canadians' bank accounts and taking them out of the economy and isolating them, and the embarrassment of a mom with the kids at the grocery store, and the bags are packed and they got to leave in embarrassment without the food, the prescriptions, the mortgage payments, and on and on. That just, we've all realized, wow, the government can do that, eh? And the federal court has just said, no, actually they can't. So at least not on such flimsy grounds. So everyone who's had their bank account frozen now has the legal right to sue the federal government. And I think that's very important.
I was actually going to ask about the implications of that. So you believe that this opens up a liability path that didn't exist before?
Absolutely. And the reason for it is this. The act not only empowered the government to take extraordinary steps because, there's an imminent insurrection and the enemy is within the gate type stuff. Remember, it was called the War Measures Act, and it was only invoked previously in World War I, World War II, and then the FLQ crisis, where they were blowing things up, killing people and kidnapping diplomats.
And even then it was seen as controversial and an overreach by a lot of people. Yeah.
This was, if the kids are listening, I'm going to say it, bouncy castles, and road hockey and people with Canadian flags singing "O Canada." So the act empowered the government to take extraordinary measures against Canadians without due process of law. But it also protected the government with an immunity screen, a shield for anything they did. Well, when their invocation order is collapsed for being illegal, struck down by the courts for being unconstitutional in violation of the charter, that immunity screen's gone too. That shield is gone. So the government's naked. They will bear the consequences of their abhorrent and outrageous and now clearly declared illegal actions against thousands, tens of thousands of lawful protesting Canadians.
So as we talk about the road forward here, and the federal government's going to appeal this, we have this path that's opened up for people to seek liability. Do you believe that this, because again, the fact that the federal government is talking about appealing this suggests that this decision standing as a warning shot against future overreach has not really been heeded. They've fallen on deaf ears, has it not?
Yeah. And the problem we've had is that the courts, as I've talked about in other interviews and here, is that they've taken judicial notice of things related to the pandemic that there was no evidence to support.
Mm-hmm.
The death data Stats Canada confirmed were completely exaggerated. There was no evidence of safety and effectiveness of the vaccine because the clinical phase 3 trial hadn't been completed. For some of them, still isn't complete, and one of them, it was only just completed in December. So this is the first time, it appears to me, that a court has taken a clear-eyed examination of the evidence and the facts before it, and clearly the circumstances that were going on in Ottawa. Remember, we had the truckers had negotiated with the mayor to de-escalate the pressure on the residential portions of the downtown and move all the trucks and consolidate them up onto Wellington, where the grievance was with the federal government.
And that movement was in progress when the Emergencies Act was invoked. And I've said in the past that it was almost as though the government knew that its window was closing because the footprint of the protest was shrinking.
I have some videos on my phone that I stumbled across, where I was in our remote backup operations center downtown during the raids. And we knew that they saw our move, which was to de-escalate, which would then take away the justification for the Emergencies Act. And that's why they rushed it in. They rushed it in because the Prime Minister was embarrassed that Canadians had stood up to his tyrannical behavior, and he wanted to punish them, and he wanted to hurt them, and he wanted to send a message that this is the new authoritarian Canada, in my view, and you don't dare question me. So he wanted to move fast, and that's why the evidence that came out was it was in part the federal government that blocked further movements of trucks from us de-escalating and giving the protest more permanence and staying power.
So one thing I'll ask you here in closing, Keith, I mean, what are you looking for in this decision? When you get a chance to go through it in a bit more detail, what would you like to see there, just as we talk about really securing freedom in the future?
I want to see whether what we all observed with our own eyes is reflected in the decision, which is that this was a peaceful protest. There was no interference with critical infrastructure, because there isn't critical infrastructure involving trade and borders in Ottawa, and that the justification just simply wasn't there. I mean, clearly the result of the decision is that's the conclusion. And so I'll be interested in looking at, and also just there's two ways in which the court can strike it down. And it looks like they did both, but I have to analyze the decision more carefully. Mm-hmm. One is on the basis that the legal test wasn't met. So assume we had no Charter of Rights and Freedoms. They have the ability to strike it down on the basis that the legal test for invocation was not met. They acted beyond their authority. The cabinet did. Another way is they met the legal test, but they violated Canadians' charter rights in a way, seizing bank accounts, etc., that wasn't demonstrably justified Section 1 in a free and democratic society Oakes test. Mm-hmm. It appears from my cursory review of the decision, the 120 some pages, that they struck it on both. So I'm looking forward to seeing both, not so much the jurisdictional analysis, because I think it's obvious, but more interesting to see the charter analysis.
Yeah, I think that will be fascinating as well. Once I get off air, I'll take a look as well. But right now, we're getting the reaction from our learned friends like yourself. Keith Wilson, KC, always good to talk to you. Thanks so much for coming on today.
Thank you, Andrew.
All right, that was lawyer Keith Wilson continuing our live coverage and analysis of the federal court's decision today, a bombshell decision, one that is, as Keith Wilson says, relieving. And as Christine Van Gyn was saying, was positively, well, I can't remember her exact word, but she was in a very good mood, as she should have been about this. We have, just to bring you up to speed here, the decision that found the Emergencies Act was unconstitutional and the measures invoked under it were. So freezing bank accounts was illegal. Freezing bank accounts, conscripting tow truck drivers, I believe, was illegal. We have the government's declaration of public assemblies as illegal. That was actually illegal. They were breaking the law, not the people who are in Ottawa to protest as part of the Freedom Convoy, which left Delta, BC exactly 2 years ago, which means it was about 2 years less a month since the Emergencies Act was put into play here. Conservative leader Pierre Poilievre has reacted to this. He's actually shared a screenshot from a True North story. I think we might have been the first out of the gate here. What Pierre Poilievre writes is, Judge rules Trudeau broke the highest law in the land with the Emergencies Act. He caused the crisis by dividing people. Then he violated charter rights to illegally suppress citizens. As Prime Minister, I will unite our country for freedom. And then he links to a petition to fire Trudeau and unite for freedom. But Pierre Poilievre's comment there, judge rules Trudeau broke the highest law in the land. And he reiterates a point he's made in the past, which is that Trudeau caused the crisis that led to that protest. So that was quite massive here. Now, Deputy Prime Minister Chrystia Freeland did comment. The Liberal cabinet right now has been assembled in Montreal, where they had a retreat earlier this week, which wrapped up today. But all of the ministers went into, literally, I saw a tweet from, I think it was Marika Walsh, if I can find it here, with the Globe and Mail, that major news that has disrupted the PM's cabinet retreat. Journalists were expecting several scrums on other issues. All were just postponed. So they sent the ministers into hiding. But Chrystia Freeland decided to make an appearance. She was not preoccupied with Disney Plus. She canceled her subscription to deal with inflation. But she had this to say about the federal court decision.
We are aware of the court decision. We have discussed it with the Prime Minister, with cabinet colleagues, with senior federal government officials and experts. We respect very much Canada's independent judiciary. However, we do not agree with this decision, and respectfully, we will be appealing it. I would just like to take a moment to remind Canadians of how serious the situation was in our country when we took that decision. The public safety of Canadians was under threat. Our national security, which includes our national economic security, was under threat. It was a hard decision to take. We took it very seriously after a lot of hard work, after a lot of careful deliberation. We were convinced at the time, I was convinced at the time, it was the right thing to do. It was the necessary thing to do. I remain, and we remain, convinced of that.
I remain and we remain convinced it was the best thing to do. So it doesn't matter that it's unconstitutional because Chrystia Freeland's happy with it. And isn't that what the law is supposed to be in this country? As long as Chrystia Freeland can sleep at night, the law and constitution and rule of law and due process do not matter. Sorry, Gladys, your bank account got frozen. Sorry there, Carlos. We know you have to, go against your will to tow that truck that you support out of the way. But fear not, because Chrystia Freeland's happy. Chrystia Freeland's happy. She's like the Wicked Witch of the banking system or something. Like, she's just out there cackling and giddy and saying, my pretties, I've frozen your accounts. Like, this is absolutely brazen, but this government has gone all in. This government has gone all in on the suppression of your right to free speech, your right to banking, your right to due process. So absolutely, why should the government care about the court decision? And it's hilarious. It's not, but I'm going to tell you something that's amusing anyway. This is a Liberal Party and a Liberal government that over the last several weeks, months, and quite frankly, over the next several years, will be making these incessant comparisons between, Pierre Poilievre is like Trump. He's Trump-like. You know what Trump never did? Trump never froze the bank accounts of his critics. Trump never did anything of the sort. Trump may have, fired some verbal pot shots at his critics. Trump certainly had a terrible choice of character of those around him, but Trump never did what Justin Trudeau did about his political dissidents and what Chrystia Freeland is standing up and unrepentantly defending, even with this court finding that it was unconstitutional. So this is going to get worse. And the federal government, as you heard there, has reviewed this. They've managed to just go through 190 pages in nothing flat, in no time whatsoever. And they've already decided they have an argument to appeal without even, the ink isn't even dry on the federal court's decision. And the federal government has somehow found a way to make this a case that they're going to appeal. So this to me is only going to inflame further right now. And to give the government a little bit of credit here, there were some instances of very violent, raucous behavior in the convoy. I captured one of them when I was there. Literally horrific stuff. You do not know who is going to get injured when you jump on ice. And you also had people sharing, again, to give the government some credit, people sharing hate symbols with abandon. This was the sight that awaited me when I arrived in Ottawa the very first weekend of the convoy to report on it. Yeah, so there was, it's subtle, you might have missed it, but there were 90 or 100 of these hate symbols. It's like a rectangle that has these two red bars on the side, and in the middle is this pointy, it almost looks like a tree or a leaf. But that is Sean says it's a leaf, not a tree. That is in and of itself a hate symbol in Justin Trudeau's Canada. So we can't have people waving Canadian flags. We can't have people that are dancing in the streets. We can't have people. One person tried to serve me a chicken wing. Do you realize how much chickens have to suffer? If that's not a public emergency, especially when I'm eating chicken wings, a lot of chickens have to suffer. That is generally why anyone that does an all-you-can-eat wing night loses when I show up. But this is what the federal government says was its emergency. Now, when you listen to what Chrystia Freeland says in that clip, which I won't force you to go through again, she does something that is very, I'll say, dangerous, because she makes up the law. She talks about how Canada's economic security was under threat. I have read the Emergencies Act many, many, many times. I have read the Emergencies Act, and it does not make a reference to economic security. It does not make a reference to it. So the federal government tried to talk about war and insurrection and unrest in the same context as some trucks were held up at the border. Now, admittedly, I think the border blockades were wrong. And the border blockades were dealt with using regular powers. They were dealt with using regular powers. So when the federal government, and Chrystia Freeland is still holding to this, says that this was a case of economic security warranting a national emergency, this is her literally making up the law. There is no justification in the Emergencies Act to use economic harm as being a threat to the security of Canada that rises to the point of what the government says was a national emergency. And I see one of my old Twitter threads on this is recirculating now. And I think I had some good stuff here that I want to pull up. Because what the federal government said here is that there was a threat to the security of Canada, which is very clearly defined. It's not subjective in the Canadian law. And they defined a public order emergency, which has a very specific definition. It requires a national emergency, and it requires all of these other criteria, which I went through during the Public Order Emergency Commission, and I painstakingly parsed for people, and I'm reading through it now. The Emergencies Act requires, for a public order emergency, a threat to the security of Canada, which is defined by the CSIS Act, specifically Section 2. You go to the CSIS Act, and its definition of a threat to the security of Canada is activities that are used that were creating threats to serious violence against persons or property. And that was the section that they pulled up here, 2C. And then, even if that were there, which it wasn't, but even if that were there, it must rise to a threshold where it seriously endangers the lives, health, or safety as Canadians and exceeds the capacity of a province to deal with. That criterion was not met. And it's why the Emergencies Act was not used in response to 9/11, floods, ice storms, the OCOS standoff, and the COVID pandemic. So this is where what the government did was it was just it was improv. The government was doing improvisation here to try to find a way to justify this emergency. And look, the Public Order Emergency Commission was an exhaustive process. And I think it was a fair process, even if I disagreed with the outcome of it. But it did not have a binding effect on the government. It produced, I think it was like a 5,000-page report. And at the end of that report, the federal government said, okay, we're vindicated. And it's funny that now the federal government is doing the opposite with a court decision, a court decision which is binding, which is more influential, which does have precedential power and authority that will bind and, I would say, hopefully constrain future governments. So if the federal government chooses to disregard this, it will completely embolden what was the very attitude behind the Freedom Convoy, which is that we must take a stand against a government that is thumbing its nose at our freedoms, at our rights, and at our civil liberties. So I cannot overstate how big a day this is. And yes, this is going to go on for years. This is going to go before the Federal Court of Appeal. Regardless of the Federal Court of Appeal's decision, it's going to eventually go to the Supreme Court. So I know this is going to be a long-standing process that we will all have to contend with. But let me just first, because I was going to talk about the Liberal government's polling in freefall here, and I actually think there's a clip that is worth sharing here from Justin Trudeau, because Justin Trudeau was speaking in Montreal to reporters about, governments need a plan. Yeah, and he was trying to sort of defend how his government has a road forward in this period. Take a look.
We know we're in challenging times right now in the world, and that's why it's so important that we have a government that continues to roll up its sleeves and take responsible, serious, steady decisions as we're there to support Canadians now and to build a strong and prosperous future. We know the Conservative Party continues to offer only insults and attacks on one side and cuts to programs that Canadians rely on the other side. That's not what Canadians need. Canadians need a government with a plan, with the capacity and the ability to continue to deliver even in these complex, challenging times, and that's exactly what we're doing. 2024 is going to continue to be a challenging year, but we're also going to see a number of bright spots as we come through the challenges of the past few years, and Canada positions itself with all the advantages we have to lead the way on many, many different fronts at a time where the world is facing real issues and difficulties as well. One thing that we always remember is that Canada is the best country in the world, and it's up to us to work hard to make it even better. And that's exactly what we're gathered here in my hometown to do.
I mean, admittedly, that was a couple of hours before the bombshell that his government was given this incredible rebuke by the federal court. But he was saying there, I mean, this again, the Liberals are, I think, 17 points behind the Conservatives in the most recent poll I saw from Abacus, which was about last week or so. The interesting thing here is that the federal government has been incredibly disconnected from real Canadians for quite some time. We see this on inflation. We see this on, I think, general cost of living issues, housing, immigration, all of these things where the government is not actually in lockstep with anyone but its own priorities. And even then, it's unclear what its priorities are. And then you have a government that has chosen to go all in on very strange things. A government that's chosen to go all in on the gender ideology stuff that triggered parental rights protests, a government that went all in on COVID restrictions, even when people were really souring on them. Remember, the trucker vaccine mandate, which really started the convoy protest, that came about when places around the world were easing restrictions. That came about where I think it was the United Kingdom was saying, yeah, you know what? Masks are gone. Border entry requirements, vaccine mandates are all gone. The UK, which had some insanely restrictive measures, they were lifting them. European countries were lifting them. And in Canada, Justin Trudeau was campaigning on them and then layering on more and more restrictions, because heaven help us if we have to deal with the menace of someone in a truck alone crossing the border into Canada without getting a vaccine. We see this, and we saw the vindictive rhetoric from the government, the punitive rhetoric. Justin Trudeau famously at that rally in Calgary during the campaign, shouting, his voice straining as he says, you don't have to get vaccinated, but you don't have a right to get on a plane or a train and put people in danger. And he was getting cheered. Like, this was an applause line for him. So all of this leads to the Freedom Convoy, which a protest that you may or may not like. And I understand it. The longer it went on, even a lot of people who were enthused and celebratory at the beginning said, okay, you've made your point, time to go home. You can have that decision. You can have that approach. That's your choice. But the point that I've stressed in my coverage of this, going back 2 years now, is that you didn't have to support the Freedom Convoy to realize that the federal government took an incredibly heavy-handed approach to getting rid of it, invoking this law that has never before been used. And then within that law, using that law of justification, uses insane measures. Again, we're talking about the freezing of people's bank accounts. The freezing of people's bank accounts. Like, that alone has made Canada the embarrassment of the world. That alone was given the condemnation of people, again, around the world, of European members of parliament, of foreign heads of government even. And this was something that the government still defends as necessary. There's been no contrition. There's not even been a sense of, yes, I concede we could have more. Not that this would have made a difference, but Christopher Freeland said, you know what, we wrote it quickly. We could have done it more narrowly, because people forget that the federal government only froze a relatively small number of people's bank accounts. And I'm not defending it, I'm not excusing it, but it wasn't thousands. It wasn't like anyone who donated got their account frozen. But under the way the regulations were written, pretty much anyone could have. If you so much as handed a cup of coffee to a trucker that was pulled over on the side of a highway at some rest stop, you could have been, under the law, subject to having your bank account frozen. It was about, I can't remember the exact wording now, but it was about providing support. And the government had no restrictions or constraints on that. The government's only constraint was that it didn't happen to do it. So this was a very heavy-handed approach that should make everyone very nervous. Now, Tom Marazzo was in the thick of this. He had his accounts frozen, and the Emergencies Act justified the freezing of his accounts. His ex-wife was affected. His ability to buy medication for his child with special needs was affected. Tom Marazzo was on the show recently about something else. He joins me again now. Tom, it's good to have you on here. Obviously, a big day. I'm curious how you feel as one of these people that has effectively been very directly vindicated by this decision.
Well, I feel actually really as excited as everybody else that I've seen on social media this morning, this afternoon already. Everybody's quite excited, and but I want to sort of temper that with the fact that they've already announced that they are going to appeal, which is, as to be expected with the level of hubris that we've come to know and love from this particular government. This is just one more scandal for the Liberal government. I'm sure that they're going to do everything in their power to get themselves out of. So, they've agreed to appeal it. But, I still feel pretty good about this. And I was just trying to go through some of the wording myself right now. Reading the document. It's 190 pages, so there's a lot to digest. But
yeah, this is the story of every guest who's been on. We should have just assigned everyone like 20 pages so that when they all come on, we get the full picture by the end of the show.
Yes, but it is good news for Canadians, and you can see that. I mean, there's a really good buzz on social media right now, and rightly so. It's justified. This is all stuff that was obvious to us even before Justin Trudeau invoked the Emergencies Act. So to see, almost 2 years, the anniversary of the convoy going to Ottawa, we're seeing now finally this vindication, I think. And I feel good about this because, one, it says that maybe there is a chance that the courts in Canada are actually functioning properly, or as the citizenry of this country would expect. Yet to be determined in the next round of court decisions, I'm sure. But it is good. It is a positive thing to see an actual judge applying the law and not just going to something like judicial notice or something and, trying to wash this thing all under the rug. So that's very positive. But, to go back to your point about the bank accounts and stuff, and I think that's a very important part of this is that, I've said this many times in interviews before, that, I was never charged. I was never convicted, yet they went right to punitive actions where my bank accounts were frozen and many other bank accounts were frozen. But gets even a little bit worse. And excuse the appearance. I was just excited to be able to talk about this. But there is a special list of people, I believe about 41 people that the police investigated. And this list of people actually went around the entire planet. The Bank of China, India, Wall Street, Bay Street, Bank of India, went around the world. The government said, if you're doing business with these 41 individuals, stop doing business with them right now. So that's yet one more layer of overreach that the government of Canada, imposed on Canadian citizens who had not been arrested or convicted of a crime.
The banking aspect is crucial here. And I know I mentioned it a little bit in my introduction of you, but I was wondering, just to bring people up to speed who might not be as familiar with your story or who might have forgotten, what happened and when did you learn for the first time that you had been swept up in this?
I think it was probably about a day or two after they invoked the Emergencies Act. And I was, my ex-spouse was trying to access bank accounts and couldn't. In my particular case, I wasn't really spending any money while I was there. So that's not something I was monitoring or expecting, but I was certainly feeling the heat from home that all of the financial assets that we had were frozen. And I mean, everything.
And no one ever gave you a call or sent you an email. It was just, you go to spend money and you can't.
Yes, and we heard that lie being told repeatedly at the Public Order Emergency Commission that, people were being notified that if they didn't, their accounts were frozen, or when they were frozen, they were notified. I've never spoken to a single person that was notified that their bank accounts or financial assets were frozen. I've never heard that at all. Not once.
And just to point, you raised this, but it's such a crucial point here that you were not, because again, if someone is charged with a crime, certainly if someone's convicted with a crime, you that goes along with losing bits of your liberty. We accept that as a society. If someone's charged with a crime, there are certain circumstances where maybe some measures are appropriate, like pretrial incarceration, although as we've seen with your colleagues Tamara Leach and Chris Barber, that can be abused in the case of Tamara. But what you had was a punishment without any charge, so you could never beat the rap. I mean, you could never really challenge this or appeal this. As I understand it, the only recourse was when the banks just decided to stop freezing your account.
Yes, and of course, nobody ever said that the bank accounts had been reinstated either. I was checking every 30 minutes to see if my account had come back online after I was already back home when the convoy was concluded rather violently by the police. So again, they went right to the punishment phase of this. And,
so we had Keith Wilson on the show a little while ago, and he had said something that I found quite interesting, that with this decision from the federal government or from the federal court, people who had their accounts frozen now have legal recourse open to them to do this. I know it's early, but is that something that you will look into availing yourself of?
Yes, I absolutely will be looking at that. I have discussed that with Keith, and I've also discussed that with Brendan Miller. Brendan Miller, as you remember, was the head litigator that we had during the commission. He was also one of the original lawyers that was part of the judicial review for the decision that we're hearing today. So it was kind of his strategy for the judicial review, which is the reason why Brendan Miller became the head litigator for the Public Order Emergency Commission, because he was on both this current decision and also was on the Public Order Emergency Commission as our head lawyer. So I have been in discussions with them to see what recourse that I may have available to me. Unfortunately, in my particular case, finance is going to be an issue if I do seek some sort of remedy from the federal government. But one thing I do want to contrast this to, because, I wrote about this extensively in one of the chapters in my book, because some of the comparisons that the CBC just wrote today about the commission versus this judicial review decision, they compared this to Rouleau's decision and tried to kind of give him a little bit of a leeway or an out. But the fact remains that Rouleau himself in the commission, I was sitting in the audience when he did this, he actually admonished one of the lawyers during a JCCF lawyer for his cross-examination of the CSIS director. And Rouleau himself in the commission admitted that CSIS did not, or that the government did not meet any of the 4 conditions of CSIS Section 2. He admitted in court, and then he came out and he said, the government met the very high threshold, which is why, there was so much anger about the decision of the commission. But now we're seeing a different judge looking at different facts and coming out with a completely different conclusion. Now, this whole decision, the federal government has said they are going to appeal. So it will go to the Federal Court of Appeal. And I hope that it's upheld at that appeal level, because if it goes to the Supreme Court, don't forget, we've got the Chief Justice of the Supreme Court, which is Wagner, who during the actual protest went into the media and spoke out against the convoy. So now we're in a situation where if this goes to the Supreme Court, we've got a Chief Justice who is going to have to recuse himself from hearing any matters related to the convoy.
Yeah, I wouldn't hold my breath for him realizing that, but I recall, and I can't remember the exact word, but I think used it. I think it was siege. He referred to Ottawa as being under siege, or it was some similar term about that. Yeah, and I said at the time, how on earth can this guy ever adjudicate any case about this? But again, we'll cross that bridge when we get to it. Tom, I'll say congratulations. I know you weren't in this action directly, but I think you're certainly one of the beneficiaries of this decision. So it's good to talk to you. Thanks so much for coming on.
Thanks, Andrew. Thank you very much.
Thank you. That was Tom Marazzo. I want to go immediately to Eddie Cornell, who was one of the applicants in this case. Eddie Cornell is on the board of Veterans for Freedom, and Eddie Cornell looks like the right half of my show logo right now for some reason. So I don't know if that's just, there we go. We'll bring in Eddie Cornell on this. Eddie, good to talk to you. Thanks very much for coming on. And also thank you very much, sir, for your service to this country. What was your role in this case, first and foremost?
Well, I was one of the litigants in the case itself. Myself and Vincent Gerses were given standing as we were directly affected, having our bank accounts frozen during the Emergency Act. So the judge recognized that both of us were harmed during that type of action, as well as many other Canadians, but both of us were given the standing and came up with a positive decision today.
I think that's an important point here. I spoke at the beginning of the show with Christine Van Geyn from the Canadian Constitution Foundation, and for groups like hers and the Canadian Civil Liberties Association, they have a very, I'll say it's a very academic investment in this case, whereas for you, this was personal. You were literally prevented from doing something as fundamental as banking because you had tied yourself to this protest. Now, look, a lot of people may not have seen you or heard of you before. You weren't one of the most prominent people here that were seen, like Tamara Leach and Chris Barber. So why were you targeted, do you think?
Well, I did speak out quite a bit, and I was one of the people that called veterans to come to Ottawa. Mm-hmm. So, I guess that placed a target on my back. I was visible in that regard. And, I worked directly with Tom and others during that convoy to support the truckers. It was pretty disturbing that, you have everything frozen. It's minus 25 in Ottawa. You can't get gas for your vehicle. You can't buy food. You have nowhere to stay, and you can't get home. I live in New Brunswick. So it was pretty difficult. If it really wasn't for the kindness of others, I wouldn't have been able to make it back here.
What was it that got you involved in this in the first place?
Well, you know, I'd been speaking out about what the government was doing during COVID quite a bit. And when I saw the truckers come forward, I just knew that I had to be there to support them in any way that I could. And I think that was probably one of the best times of my life in this country, to see the unity across the country and stand up to draconian measures that, you know, the government imposed over the course of the COVID pandemic. And to see the reaction, you know, of people when Canadians stood up and said, hey, this is it. This is enough. We're not doing this. I knew I had to be part of it.
Keith Wilson earlier, the lawyer who at one point represented the convoy, had said, and I was just chatting about this with Tom, that anyone who had their bank accounts frozen or was targeted under the Emergencies Act measures now has some recourse available, because we have this legal ruling that you could use to go after the government. And I wanted to ask you, first off, if you intend to do that, but also what would make you whole? I mean, the government, you know, they've unfrozen the bank accounts. What could they do, if anything, that would rectify that to you?
You know, I'm really kind of looking at all my options at this point. I haven't made a decision moving forward what's going to happen. I'll be consulting with my legal team and make some decisions very soon. And I'll go from there. I think that I don't want to, you know, speak hastily and say something that could counter any possible win that I might have in the future in regards to this. So, like I say, for now, I think I'll just kind of keep a close eye on this decision. I know that Chrystia Freeland has come forward and said the government will appeal. So I'll speak to my legal team and see what options we have.
You served your country for decades in uniform. Did you ever imagine you would end up having to sue that same country?
No, that would be the furthest thing from my mind. I never thought that I could see our government turn on the Canadian people and also turn on veterans who were standing in support of truckers with medals on and be beaten into submission and thrown out like yesterday's garbage out in the middle of nowhere after they drove them around for a couple of hours and processed them and just dumped them off in the middle of nowhere. It's disgusting. And they should be ashamed.
And I mean, you had joined the military. Was it 1975? Do I have that correct?
Yes,
yeah. So this was
correct.
5 years after the FLQ crisis, when the War Measures Act had been invoked to deal with this very controversially. And I'm guessing that even by the time you enlisted, that would have loomed large on why, you know, using war measures in a domestic capacity for law enforcement was not acceptable. So you fast forward and then see the Emergencies Act come into place. And I think that's why so many veterans were just absolutely shocked and dismayed by this.
That's a good point. I really believe that, you know, veterans recognize probably more so than most people how, you know, a government can abuse its power. And that's why veterans came to Ottawa and stood up. Like, we don't speak for, I'm part of V4F, one of the founders of V4F. And, you know, we don't speak for all the veterans, but the ones that did come and supported the trucker convoy, they were the people that recognized that this government is overreaching. And, you know, they were basically power drunk and wanted to squash any dissension from the public. And they would go to any length to quell people from speaking out.
All right. Well, I appreciate very much your service, and I'm glad you were a part of this case. It's a very important case, and you've certainly cemented your name in the history books here. Not that that was your intention, but congratulations on the win, Eddie, and thank you so much for joining us on such short notice.
Thanks, Andrew. My pleasure.
Eddie Cornell, one of the applicants in the now successful fight in the federal court against the federal government's invocation of the Emergencies Act. We could probably do this all day. We're going to call it here. I've got to actually read the decision in full, and we'll have a bit more of an academic and legal analysis on the show tomorrow. But I wanted to bring you some early reflections and reactions to what was going on here. That's all coming up tomorrow on The Andrew Lawton Show, Canada's most irreverent talk show here on True North. Thank you, God bless, and good day to you all.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.